Hello, everyone. Good morning, and welcome to this panel discussion on Dr. Tolulope's new book, Regional Cooperation, Intellectual Property Law, and Access to Medicines. My name is Omkar. I'm a research fellow at the UQ Law School and work with Dr. Tolu on intellectual property issues here. To discuss Tolu's new book, we have with us today a set of wonderful panelists. We have Dr. Amma Kawani, who is lecturer in law from University of Leeds. We have Mr. Chimdasa Sega, who is a research student from the Chinese University of Hong Kong. And we also have Dr. Olasupo Owoi, who is Humboldt Research Fellow at University of Augsburg, Germany, and Professor in Law at the Leeds City University. From what I understand from the book is a discussion on how least developed countries, a categorization under the World Trade Organization, can enhance their regional cooperation among themselves for increasing their pharmaceutical production and distribution, and thereby also address public health needs. I think this is the core idea that the book touches upon, and I'm sure that the author and the panelists here today have much more to add to this. So without any further delay, we'll begin this discussion. We'll start with Dr. Tolu speak on his book for 15 minutes, followed by each panelist for about 10 minutes. Audience can use the chat box function anytime to drop in the questions. We'll collect all the questions at the end and have the author answer all these questions. Thank you. Dr. Tolu, over to you.
All right. Good morning, good afternoon, and good evening, everyone. Thank you very much, Dr. Omkar, for that introduction, and many thanks also to the participants and to the panelists, Dr. Chim, Dr. Owoi, and Dr. Amaka. Many thanks for joining me. So it's actually a difficult task for me to discuss this book in about 15 minutes, but I will try to, because I would really want us to have more time to discuss and deliberate. So first, I will talk about my motivation for the book, and then I will try to highlight and summarize my key findings and give my final thoughts. So my motivation for the book is, rooted in my belief or ideology as a Pan-African. I strongly believe in African solidarity and continental union. And it's important to note that, discussions regarding regional cooperation on the African continent is not new. Some of us will remember very vividly that famous speech by Kwame Nkrumah in 1963 during the founding of the Organization of African Unity, when he said that Africa must unite now or perish. So bringing it down to IP law, and health law and the access to medicines discourse. Scholars like Professor Chiruka, Professor Frederick Harbord, Professor Richman, Dr. Owoi, Dr. Olatunji, they've also written extensively on this idea of regional integration. Professor Bryan also, has always called for a holistic approach in solving the access to medicines conundrum. Of course, regional coordination is a very key component of that. So I must acknowledge that my book actually builds on this scholarship. And of course, I uniquely focused on the East African community to further show why regional cooperation is to be preferred over national action. So by way of background, as we all know, there continues to be, to exist an unacceptable inequality in the health status of developed and, less developed countries. And as we know, every year, over 10 million people die needlessly because of lack of access to essential medicines, principally in less developed countries. And in recent times, the cost of medicines, has become one of the most significant barriers to access. So it is in this context that, efforts have been underway over the past decades, to make medical technologies work for those in less developed countries. And a major component of these efforts, has focused on the expansion of patent protection on pharmaceutical products and pharmaceutical processes under the WTO's TRIPS agreement, which is a very cardinal focus in this book. So what I did was to do an extensive review of literature from 1986. Why 1986? The Uruguay round of trade negotiations actually started in 1986. And then I reviewed literature revolving around the founding of TRIPS agreement in 1994 itself, and then the post-TRIPS era. And then I categorized the existing literature in this field into three. The first, focuses on the harmonization of intellectual property rules at the global level. And then, discussions regarding the bargain between the global north and the global south and the conspiracies that greeted the negotiations of TRIPS agreement itself. And then the second set of literature, explores the post-TRIPS era, discussing the seemingly negative impact or otherwise of intellectual property law on access to medicines in less developed countries. And then the third set of literature, of course, took a radical position saying that TRIPS agreement or intellectual property law has nothing to do with the lack of access to medicines. They argued that the challenge of access to medicines predates TRIPS agreement, and as such, solutions to this problem should be sought outside the intellectual property system. So building on this literature, the first thing I did was to give a conceptual clarification to access barriers. And in this book, I argued that access barriers actually has four major components: affordability, availability, quality, and accessibility. So it's one thing to have access to vaccines. It's another thing to for the vaccine to be, it's one thing for a vaccine to be available. It's another thing for it to be accessible. And it's another thing for it to be affordable. And it's another thing for it to have the right quality. So for this purpose, a holistic approach to driving sustainable access to medicines must take into account both intellectual property and non-intellectual property issues, such as sustainable financing, price and quality control, dosage and efficacy of medicines, procurement practices and procedures, and supply chains. So this conceptualization of access barrier also made me to find that access to essential medicines, it's a complex process in which intellectual property rules are only one component, and of which sole national action of least developed countries may not be able to tackle. So having said that, one may actually think that intellectual property law is of secondary importance, but on a closer analysis in my first chapter, it became clear that intellectual property component cuts across all these issues, like both IP and non-IP issues. And indeed, IP is a pivotal, if not dominant factor in organizing and coordinating efforts to engender sustainable pharmaceutical access. So the primary thesis of the book is that regional collective strategies to drive access to medicines is the way to go. And it can in itself produce an organizational infrastructure that can deal with both IP and non-IP challenges to pharmaceutical access in least developed countries. Now, the second chapter provides, a crucial contextual background information to evaluate the potential of this regional collective approach to address these issues. And I did this by, mapping the social economic context and healthcare systems of East African community countries. So now, the East African Community is actually a regional intergovernmental organization founded in 1999, and the EAC, that's the abbreviation, is currently made up of 7 partner states. You have the Democratic Republic of Congo, the Republics of Burundi, Kenya, Rwanda, South Sudan, Uganda, and the United Republic of Tanzania. So I found that, of course, economically, all EAC partner states are categorized as least developed countries, except for Kenya. And demographically, the region has a young population and rising healthcare cost, which has been projected to, to continue to increase. And then, in addition, the region hosts, little or no research and development in the pharmaceutical sector, and possess little or no pharmaceutical manufacturing capacity. From the demand side, the EAC population, the population of the region, stands at about 150 million, and all the 7 countries are among those, countries identified globally as having a very high burden of communicable and non-communicable diseases. Now, from the supply side, the region depends heavily on imported pharmaceutical products, drug donation, and then the few local firms actually lack capacity to manufacture advanced formulations. So my finding, actually show that that strategies premised on national action alone will definitely entail high transaction costs in attempts to overcome the endless array of technical and legal and also infrastructural obstacles in this regard. And most importantly, the chapter highlights, how national level attempts to tackle these challenges of revolving around access to medicines, in Burundi, in Tanzania, and South Sudan have fallen short over the years, underscoring the need for collective regional approach. So, like, even if a single country succeeds over a specific medicine, just like some of us may know that Rwanda used the Doha Paragraph 6 system to import some ARVs between 2007 and 2000 and around that period, the whole process must have to wound up and then start over again for the next drug in the next country, with all the legal, economic, and political costs to be repeated without end. So based on the contextual analysis of this region, the second chapter strongly recommends a regional strategy, like a collective strategy as opposed to a single state action. So in the fourth chapter, I did a survey of the national IP laws of EAC countries to better understand the nature, the scope, and then the depth of their patent laws, with particular focus on their utilization of TRIPS flexibilities to facilitate pharmaceutical access. So the flexibilities I analyzed were the Ebola exception, reset exceptions, parallel importation, test data exclusivity, opposition procedures, and of course, compulsory licenses. And my findings show that these countries actually lack explicit and workable provisions implementing key TRIPS flexibilities. And the chapter also finds that coherence remains a big challenge, and this may definitely affect the overall usefulness of a regional approach to solving the access conundrum in the region. So the recommendation is that these countries are net IP importers, and it would seem that the best approach would be to ensure that the pharmaceutical patent laws and policies are framed to take full advantage of TRIPS flexibilities. So in the fourth chapter, I did an evaluation of the regional mechanism carved out under Article 31bis, paragraph 3 of TRIPS agreement. And as we know, 3 types of compulsory license could be discerned from Article 31 of TRIPS. For countries with local manufacturing capacity, we have use by individuals or government use. And in the same vein, countries with little or no manufacturing capacity are able to rely on the provisions of Article 31bis to issue a compulsory license, which a recipient local pharmaceutical firm can use to import essential medicines from an overseas pharmaceutical firm. So this regime has been tagged largely, compulsory license for export. So the compulsory license for export has a special regional appeal to regional communities, to regional economic communities like the EAC, because they are allowed to use this regime to bulk procure essential medicines, including active pharmaceutical ingredients, from overseas, for subsequent distribution within among their members. So this hypothetically means Kenya, the only EAC developing countries, can front the use of compulsory license for export regime to bulk procure patented active pharmaceutical ingredients or essential medicines or vaccines, for sharing amongst partner states. Unfortunately, my analysis reveals that Tanzania is the only country that has implemented this compulsory license for exports regime in its domestic laws. Other countries have no such provisions in their laws, and this also presupposes the challenge of coherence and lack of domestic implementation. Then I know, of course, I must acknowledge that the Article 31bis of TRIPS has been very controversial. The Doha Paragraph 6 system has been very, very controversial. But I actually argued that the limited use of the system may not be an appropriate measure of its success, as no country has demonstrated any evidence of obstacles to its use, when such use may arise. And then the fact that Rwanda has been able to use it as a single case, demonstrates that the system could work when necessary, and it could play a supportive role in the wider efforts to drive access to essential medicines. So in the fifth chapter, I addressed the question of successful establishment of regional production facilities in the EAC from an IP trade, design, and management perspective. So given the importance and urgency of the issue of local production for regional health security, I took as a starting point that, replicating production facilities in each and every country might be inefficient and costly. So I argued that a systemic approach to creating a network of production and supply in the region would be preferred. I also discussed, regionalizing production from a development and health perspective and proposed, a variety of models that could be available to choose from, highlighting questions of tech transfer, IP, and other production incentives. So in the sixth chapter, I examined the extent to which the existing international human rights laws provide a framework for equity in global vaccine distribution. And the chapter explores the delicate balance between protecting IP and promoting public health and then safeguarding human rights. So in the chapter, I appraised the decision regarding the proposed waiver of IP for COVID-19 treatments at the WTO during the pandemic. So I was able to fit the argument into the crux of the book, arguing for the necessity of regional coordination for future pandemic preparedness. So my final thoughts, so regional strategies, no doubt, offers lots of advantages, for instance, using the EAC as a case study, leveraging the population of the region to achieve, economies of scale. And in fact, I actually found that this approach has the potential over the long term to facilitate the consolidation and development of pharmaceutical manufacturing capacities throughout the region with, Kenya, Uganda, and Tanzania, each at the moment possessing moderate manufacturing capacities, so taking the lead in this regard. However, while the EAC partners have in recent times, marshaled the possibility of transforming the region into a regional pharmaceutical center, the move towards regional integration, still appears to be half-hearted, and there's really little evidence to suggest that the moves will result in any tangible plan of action. So EAC partner states still embrace, the protectionist and nationalistic outlook, and we know with national health concerns overriding common regional good, and we still have, issues revolving around political will and leadership, remains an open question in the EAC and on the African continent at large. Well, so the main idea of the book is clear, by implementing coordinated strategies at the regional level, the East African community can address challenges of access to medicines. And the key message is that public health is a common concern and unity within the region is crucial for its prosperity. Thank you very much for listening. Dr. Umka, it's up to you.
Sorry, yeah, thank you so much, Tolu, for that wonderful oversight of your book. So I'm guessing now we'll ask each of the panelists to come over and critique and raise their concerns over your book. And I'm guessing once all the panelists finish their comments, you're going to respond back to them. Is that right, Tolu?
Yeah, that's okay.
Yeah. So now I invite Dr. Amakawani, lecturer in law at University of Leeds, to take over and provide her comments and critiques of Tolu's book. Thank you.
Hi everyone, my name is Dr. Makavani. I'm at the University of Leeds. I'm here in the UK. I want to start off by congratulating Dr. Tolu on such a big piece of work, a brilliant piece of work. I'm not here to offer criticism because I know writing is hard. Sometimes when I have to write a paper, I sit down and think about all the decisions I've made that brought me to that point, and I'm thinking I should have done something better with my life. So listen, well done for writing such a book. For me, I think what stood out or what I enjoyed reading the book in the short space of time I had to read it was the way you ended by looking to the future. So the last two chapters, reading the last two chapters, again, I'm a critical IP scholar, a realist, but also a critical IP scholar. I'm reading the last two chapters and also reading, hang on, let me pull it off. Reading chapter 4 on TRIPS amendment and special regional TRIPS amendment, special regional treatment is anyone that reads this critically will see from you discussing these two issues, will see the problem we have with intellectual property. Again, as an area of law, again, within the international economic capitalist system, which is where it operates. And then on the third pie is the lack of political will, as you mentioned, amongst leaders in Africa, right? And so if we remember correctly, or rather those of us that really know TRIPS agreements, we know that I think Article 8 or Article 7 of TRIPS encourages tech transfer, and Article 62.2 of LEADS also discusses tech transfer. And as you rightly pointed, it goes, it states that governments of developed countries really need to provide the incentives for this sort of tech transfer to happen. We know intellectual property is a very individualistic right, and so the government doesn't really have, intellectual property rights to tech transfer. So that means they have to create incentives and enabling environment and encouragement to companies within their countries to be able to encourage such activities to least developed countries. And what we saw during COVID is that capitalism will always capitalism, right? There is, first of all, during COVID, we saw that even so-called developed countries were very selfish and very uncaring in the way they handled the whole access to COVID vaccine. We saw again pharmaceutical companies caring more about their profit and shareholder benefit from the amount of money they're making. And then you have the cases where most of the countries in Africa, in Latin America, in Asia, did not have the same access to vaccines that countries in the global north had. So you have these three issues where a government will always focus on itself and its people, and also a government doesn't have, say, a pool of IP rights to share, right? It has to encourage the companies, the transnational companies within its jurisdiction to transfer this technology. How do you reconcile that when the companies are only also invested in making sure that they make profits, right? And so these two issues, I like the fact that you highlighted them, and that is really the main problem with TRIPS agreement, the main problem with having international IP rule within a capitalistic system, right? Capitalism exists, or capitalism works because certain people are being exploited. And so until we deal with that, with the system within which these IP rules, these TRIPS agreements engage in, we're not going to have this sort of solution. Or, as you started the talking about Kwame Nkrumah, we're not going to have such decolonization or freedom he talks about, right? Because we have spokes in the system that actively ensures that the goodwill, the good health, the human rights of every single person in this whole world, the right to health, the right to life, is recognized. I don't know the way forward. I mean, I can't say less. To be honest, I don't know the way forward. But my hope, which I'm sorry to be negative, keeps diminishing every day when I look at what's happening within the continent, the lack of political will within the government, within Africa. How do you reconcile AFCTA, considering the fact that freedom of movement is not even assured for all Africans within Africa, right? So it's just, I don't know, but it's good you've written this. Hopefully, policymakers and negotiators of AFCTA, and again, wishing on the stars, leaders, African leaders, will get to read your work and start asking this question. Perhaps from their vantage point, they can see, they might come up with a solution that we, the scholars, can't see because we don't have access to the sort of information they have. But all in all, I think this is a very richly written book, very needed within the field. I would definitely be using this to teach. And so congratulations and well done on such a beautiful piece of work.
Thank you very much, Dr. Amaka. I really appreciate it. Thank you.
Thank you, Dr. Amaka. That's a wonderful commentary on Cholo's book. Now, I invite Mr. Chimdasa Sega, who is a research student at Chinese University of Hong Kong, to share his insights on the book.
Okay, hello everyone. First and foremost, I congratulate Dr. Adekola on the publication of your book. After reading the book, I can say that your professionalism and your meticulous research have made the book both informative and enlightening. A job very well done. The book is a very fitting discussion of the complex relationship between patents and access to medicine, especially coming out of the COVID-19 pandemic. This book sheds light on heated conversations that we had during the pandemic from the perspective of developing countries. Even though the main study is on East African community country members, I do believe that the findings of the book are also pertinent to all other developing countries. Generally, after reading the book, I think the book itself is a reminder for developing countries that in dealing with public health issues or public health emergencies, solutions are to be found in regional or sub-regional cooperation as opposed to national or even a top-down global body such as the WTO. I think one very important contribution of the book, I believe, is on how best developing countries must leverage TRIPS flexibilities for pharmaceutical access. Because we all remember during the pandemic and at the beginning of vaccine talks, this was before vaccine nationalism took over, there were pronouncements by different bodies, by heads of states, that vaccines are global public goods and everyone, whether they live in developed or developing countries, they will have access to vaccines. But that happened to be not the case, particularly like during the early stage of vaccine production. And what has been missing from such conversation, and which I think the book brilliantly conveys, is that making use of available TRIPS flexibilities first and foremost is the responsibility of developing countries themselves. I remember when India and South Africa submitted a proposal for a COVID waiver in October 2020, one of the reasons that they set out in the proposal is that developing countries do not have the necessary legal and institutional mechanisms to take advantage of these TRIPS flexibilities. This book, I think, under Chapter 3 captures this spirit because in a way, these countries are using their own failure to domesticate and to consolidate TRIPS flexibilities as one of the reasons to push for a COVID waiver. And Chapter 3 brilliantly digs into the East African member countries, and it assesses the status of regional use of these TRIPS flexibilities. I think it assesses specifically flexibilities such as the patentability criteria, parallel importation, and other flexibilities. And it shows that the EAC country members themselves did not adequately carry out their responsibility in that aspect. For instance, in terms of adopting strict interpretation of criteria of novelty or inventive step, or even excluding new use or subsequent use of medicine, the book finds that the countries or their patent legislation could and should do better. The same goes, for instance, adopting a system of international exhaustion, because in the book, there is a discussion on some of the countries in EAC member countries, specifically, I think it is Tanzania and Rwanda, that still adopt a system of national exhaustion, which adversely affects access to medicine initiatives, specifically in relation to addressing public health emergencies. I think Chapter 3 also digs into how these countries approach regulatory review exception, even though most of the countries, overwhelming majority of them are dependent on imported medicine, still their patent legislation does not incorporate this important exception in dealing with or in enhancing access to medicine. So the book, I think, uncovers the lack of adequate use of such flexibilities and the lack of legislative tools for the utilization of these flexibilities in the study area. I think these countries must take note of these findings and address this critical gap. I think another important contribution that I took away from the book is chapter 5, which examines the need to create and strengthen a regional value chain for local pharmaceutical production. Specifically, it studies in detail the challenges in terms of having this pharmaceutical local production capability in the East African region. It talks about infrastructural deficits and the need to address them, and specifically the lack of harmonization, particularly policy coherence, such as on tariffs, on tax issues, and generally the hindrance in terms of technological transfer issues that must be addressed to enhance regional local pharmaceutical production. After such discussion, the book proposes solid and evidence-based policy solutions that enable production of pharmaceutical in these member countries. And I think it is also important to highlight the book's finding that regional cooperation or sub-regional cooperation in terms of having a common policy framework, a coordinated policy framework, is very crucial to enhance pharmaceutical production in the region. It's very difficult to summarize the whole finding of the book in a few minutes, but in conclusion, I can say that the book is brilliantly written. I think the book is a must-have for academics, for policymakers, and for researchers engaged in intellectual property law, international trade law, and specifically for those who study the intersection between these two branches of international law. So I urge everyone here to buy the book, not only buy the book, but to recommend the book to their institution so that everyone in the field will have access to this stellar academic work. I once again congratulate Dr. Adekola on such remarkable work. Thank you very much.
Thank you, Mr. Chimdasa, for such detailed insights about the book. Now I invite Dr. Olasupo Oi, who is a Humboldt Research Fellow at the University of Augsburg, Germany, and also Professor in Law at Leeds City University, to share their insights on Dr. Tolu's book.
Thank you very much, Dr. Amka. I will start by joining Dr. Vani and Chin in congratulating Dr. Adekola on this laudable project. Access to medicines is actually one topic that continues to generate significant interest globally. And it's good to see great projects on this topic from Africans on Africa. And I think we need more of such projects. We need to give more attention to how to address this problem in the continent. I will make a few general remarks on the book and the issue in general. I think the book really covers the TRIPS flexibilities, the general IP provisions that could be used to address the problem, and it goes beyond just discussing TRIPS flexibilities. It equally looks at non-IP barriers, like Dr. Adekola mentioned also in his speech. There are a few issues I think we should actually reflect upon when looking at this problem. Dr. Adekola did mention that there are scholars who believe that IP is not a problem, and it's more about affordability, free trade, and essentially non-IP barriers, including even logistic issues. Now, one major reason I think some scholars contend that IP is not a problem is because there are waivers in place, especially for least developed countries. Now, when you look at the East African community, for instance, I know Kenya is considered as a developing country. With the exception of Kenya, I think the remaining countries are almost considered as least developed. Or almost all, I mean, I'm not too sure, but I'm very sure most of the countries in the EAC are categorized as least developed countries. I know Kenya is above LDC level, but probably all the others will be LDC. And that basically means they still enjoy the waivers. So there is a waiver for LDCs not to implement TRIPS agreement until 2033, I think, January. And there is another waiver for LDCs not to implement patents in relation to pharmaceuticals until 2034 July. So if least developed countries do not have to implement TRIPS agreement, and more than 50% of African countries are actually least developed. There are 54 countries in the continent at the moment, I think, and at least 33 of them are least developed countries. So the question is, if they are not implementing TRIPS agreement, then why is there a problem with intellectual property in the continent? Now, I think that is taking a view of the problem that is not a holistic view. The problem is, like other speakers have rightly pointed out, there is a in the continent. And if we have to go with imports and we do not manufacture, it essentially means that we do not have access to these things, except we get it from countries that are bound by the TRIPS agreement. So yes, I think the problem with the waivers is there is this very strong dependence on import. And what that means is you get these products essentially from countries with the capacity, I mean, with very strong intellectual property provisions. Now, when we talk of compulsory licensing, you can use that more easily when you have a significant manufacturing capacity, which we do not have in the continent. So essentially, we are going to depend on countries that have implemented strong intellectual property frameworks. And there are a lot of issues surrounding even Article 31 base of the TRIPS agreement, which allows for the exportation of products made under a compulsory licensing framework. I remember that Dr. Adekola did, mention the fact that the problem doesn't seem to be with the compulsory licensing framework, because Rwanda successfully imported under that system, and as such, it's a system that works. Theoretically, that seems to be so, but I'm not sure that is entirely the correct picture, sadly. Well, we should ask, why has only one country used the system? Is it because other countries are not interested in using it, or it's completely unnecessary? I think we may benefit a little bit from a WTO report. I don't have the exact citation offhand, but I can provide it if you want. I know I've referenced that particular report in one of my previous works. Essentially, India did make a report to the WTO Council for TRIPS that the system was unworkable, and attempt by another country in East Asia to use it through India. The country contacted India and wanted to import products from India under the system. And the bureaucratic bottlenecks, the administrative challenges, and the processes required were just too onerous. And the whole idea was abandoned because it was more or less impracticable to follow it to the end. So we all know about the United States Section 301 list and how they use that to harass countries that take a proactive approach to the use of TRIPS flexibilities, or that tend to adopt a rather liberal approach to those flexibilities. And I think the threat of Section 301 is a real deterrent factor for many countries. And that is still a real threat that exists beyond the administrative processes expected or required under the compulsory licensing framework. So there is probably need to look more deeply into the reasons the system is not being used, and not just take it that, well, Rwanda used it. Even Rwanda was not a very smooth experience. The Rwanda experience wasn't an entirely smooth sail. It took a couple of years for them to get through the process. And I think there was significant international support to make that happen at the time. So we need to look more deeply and ask more questions on why is it not being used? Is it because it's unnecessary? I don't think it is unnecessary. And I know at some point Ghana tried to use the compulsory licensing system too, and they just didn't follow it through as well. So why are countries abandoning the process, like India reported to the Council for TRIPS? That is something we need to, more work, more investigations can actually be done on that. That's probably the political and administrative part of the problem. And it may not be something scholars can easily deal with, but it's still worth looking into why this system is not being well used. The test data, I don't think I need to go into those TRIPS flexibilities, but essentially more practical issues. Now, let's look at the African Continental Trade Area. We are all happy that eventually has come to place. It's now in operation. We know we have a continental trade area in principle, in theory. In practice, I have my doubts about how well that is going. I share the sentiment of Dr. Vani about the challenges in the continent and how disappointing the things we see and read about the continent at the moment. The news, the developments are not so encouraging. So there are disappointing developments, no doubt. And while we have a trade area that we would ordinarily consider as an encouraging development, I think the African Continental Trade Area is still struggling significantly. And a lot of their agreements are only agreements in principle without any practical implementation framework that is being used to support those agreements. And now let's look at, there is a protocol on intellectual property, which is a good development. I've looked at that protocol. I still see a few issues as challenges even in the written protocol, but the reality is not much is even being done to implement these written agreements. What are the problems with implementing the free trade agreement in Africa, the continental trade agreement? A major problem is protectionism. A lot of African countries still believe so much that they need to protect their national interest, they need to protect their economic interest. And I was in Ghana at the Intellectual Property Office some years ago, and one of the senior officials at the office was telling me that she wouldn't be happy to see Ghana open its borders to foreigners because they would take over the economy and it would be hard for Ghanaians. Sadly, it's a sentiment that is shared across the continent. South Africa is being protectionist. So when are we, Dr. Vani mentioned the issue of free movement of persons. I think that will continue to be a real problem in Africa, despite the establishment of the African Continental Trade Area. And sometimes you wonder if, I don't want to be pessimistic, but I have my reservations about the likelihood of the trade area being really what it should be in the next 5 years. Maybe in another 10, 20 years, significant development could be made. But I think it's going to take a while for Africans to truly open their borders to fellow Africans. So protectionism continues to be a big problem. It's not an IP issue, but maybe we should call that a political issue. I don't know if it's right to call it a trade issue. The problem is it doesn't look like Africa is ready for integration. Within the regional bodies like the East African Community, the West African Community, there are still challenges of integration. Recently, I read that 3 countries actually moved out of ECOWAS. They decided to withdraw from the West African Economic Community because those countries are ruled by military dictators. So there are already integration challenges at sub-regional levels. Let me not say regional level exactly. How much more a continent-wide arrangement? If West Africa cannot be fully integrated, East Africa with just probably about 8 countries or thereabouts cannot be fully integrated, then it presents a massive challenge to the continent-wide area. Now, we have all been talking about the need for regional cooperation. I think one other thing we need to look more deeply into is how do we use, in what framework do we need to use at the regional level to promote local manufacturing capacity? We know regional cooperation is important, but who drives it? The private sector, the government? I think it was Dr. Vani or also probably Dr. Adekola as well that mentioned the issue of government incentives to promote innovation, all of that. The protocol, the Africa Continental Trade Area Protocol on IP also mentions the need for that government incentives to promote innovation. I noticed a big loophole in the protocol for the African Continental Trade Area on IP, and that's in relation to test data exclusivity. That's one area that a lot of scholars have actually identified as a potential problem, as an additional barrier to the access to medicines challenge. And it's disappointing that that's not really dealt with in the African Continental Trade Area Protocol for IP. So I think there are a lot of issues that still need attention, and there is still a lot of work to be done in this space, both in relation to the IP and non-IP barriers to access to medicines. And Dr. Adekola's work is certainly a great addition to the existing works in the area. And I hope we'll continue to work in this area. People like Dr. Vani and Dr. Adekola will not withdraw out of pessimism. I know a senior academic, Peter Draws in particular, to be specific. It looks like people are getting more discouraged because the results are not encouraging, things are not improving. And it's looking like a lot of scholars are withdrawing and getting discouraged with how things are going. But I would say for those of us from the continent who are definitely mostly affected by this problem, we shouldn't also get to abandon the work we are doing because we feel nothing's happening and it's becoming like we're just saying things without getting any result. So thank you for the time. I think my time is already up. And thank you for the invitation too.
Yeah, thank you. Thank you very much. Dr. Muka? Okay, I'll just try to respond to the comments, and I really appreciate all the comments. The first comment. Okay.
Meanwhile, the audience, if they have any questions, you can drop in your questions in the chat box, and Tolu and the panelists will address them once Tolu addresses the panelists.
Oh, sorry to butt in. I wasn't hearing you. Thank you very much. Many thanks to the panelists. Dr. Amaka, thank you for your comment and for staying awake. I know it's it's time to go to bed now in the UK. And thank you for highlighting that Article 66.2 and Article 67 of TRIPS, the bargain during the negotiations of TRIPS, for tech transfer and all those incentives, and the fact that after 3 decades, we are really seeing nothing. Thank you for your kind words also on the book. And I know you've written in this field also extensively, and we hope to continue to push for a better climate in the access to medicines ecosystem as we've been encouraged by Dr. Supo. Thank you very much for your kind words and for highlighting that point also, and many other points that you also made mention of. And to Mr. Chim, thank you so much for that very comprehensive review of the work, and for your very kind words. Thank you for highlighting some of my key findings and bringing them to bear. Hopefully, it will get to the right quarters. Like, we cannot change the world for a little here, a little there. I believe we can make some impact and see a better world in this field. Thank you very much for joining in. And to Dr. Supo, thank you very much also for your insights. Of course, you've covered several issues, and I do not want to go into the arguments, regarding the Doha Paragraph 6 system. I know you've written extensively in this, within this space, and of course, we all have the same goal to just, ensure that the vulnerable, have sustainable access to medicines. And thank you for that leadership-oriented comments also, that we shouldn't be discouraged. It can be very, very discouraging. Like, this debate has been on for a long time, and it's like we're trapped. It's like we are just going backwards, right? But we'll continue to persist, and thank you for your leadership in this field also. So if we have any questions, maybe we can throw it open. And yeah, thanks to the panelists. I really appreciate your time. Thank you.
We have a question here from the audience.
Okay.
The question reads, how can the AFCFTA platform help to achieve IP law and policy coherence on the continent?
Yeah. I think Dr. Owoye can take this. Is it there? Okay. Okay.
Yes. Sorry, what's the question again?
The question is, how can the AFCFTA platform help to achieve IP law and policy coherence on the continent?
Well, I think having policy coherence is not going to be so difficult. Essentially, policy coherence is having provisions that essentially are designed to promote public health needs and having a uniform or harmonized standard for that. To a large extent, I think significant steps are being taken in relation to having policy coherence. What I see as a major challenge is not just policy coherence, but the political will to really implement things and put things in action. So I think it's while I do note that the protocol, the IP protocol for the African Continental Trade Area is not a perfect document. It's a good development and a great step in the right direction. But those are, the provisions there are more like lofty objectives that are not being implemented in any meaningful way. So I do believe the Continental Trade Area can be a very strong platform for implementing the TRIPS flexibilities. If we have a truly integrated region and we have a trade area that works, that is truly integrated, open borders, free movement of goods and services, you have a market of about 1 billion people that already provides a very strong market for any local industry. One of the challenges for local manufacturing is a viable market. And when, just like Dr. Adekola mentioned, if a country like Rwanda with about 11 million people should go into local pharmaceutical manufacturing, there's going to be a challenge if the market is only for Rwanda. But when you're dealing with not just 11 million people, but 1 billion people, definitely there is a big incentive for that. And that's where the regional integration issue comes in. So yes, if we do have a continental platform, it creates a very strong market. For policy coherence will mean that you don't have to be concerned that the rules in Ghana will be different from the rules in Nigeria or Uganda. I think substantially, I don't think that is the biggest problem at this stage. I think the biggest problem is actually the implementation, and the better we get on with the implementation arrangement, the more success we record in relation to implementing the continental trade agreement, I think the better deals will actually get. Things will improve. So we should be more concerned about how well are we implementing the lofty objectives of the continental trade agreement as against policy queries. But yes, the platform is a strong platform for addressing the problem.
Yeah, I think Tolu, you have some compliments from the audience here.
Many thanks.
Yeah. Think if there are no more questions, we're at the end of our time. Before we end this session, I want to thank all the panelists for being here today and sharing your insights about the book. And also congratulations, Dr. Tolu, again, for coming up with such fascinating work. Thanks also to Caitlin from the law school who has helped us in conducting this event very seamlessly. See you all next time. Thank you.
Thank you. Bye-bye.